Hey, good morning, everyone. In Introduction to Law, we're in Chapter 4, which covers the executive or the president and administrative bodies. I think most importantly, for those of you that want to become paralegals or attorneys or legal assistants or just have an interest in what law is, it's the administrative agency aspect of it that really is going to play a much more practical and functional role in your practice. There's no question about it. That doesn't mean we shouldn't know about the executive. And why am I calling it the executive as opposed to the president? We have a federalist system, and I think the book was a little bit weak on this in the sense that there are executives both on the state level in much of law that will encounter as attorneys and citizens and paralegals will be derived from state law. And so it's just as important to consider the role of the executive on the state level, the governor, as it is on the federal level, which is the president is the executive on that level. The book starts off with, I think, a little bit of an interesting introduction talking about anybody can be president and you kid me too and all of that kind of stuff, and talking about the different contrasts of the characters that have held that office. I'm a little disillusioned by that because as a kid growing up, I always wanted to be into politics and things like that. The reality is it's a very, very significant long shot to ever become the executive, even on the state level. Is certainly a long shot as well. But it did talk about the evolution of the executive, or the president, I should say, historically from, I don't want to say it was ceremonial, it always had an important role within our constitutional structure, but the influence of the executive on the federal level has definitely evolved over time to become more influential and powerful and more iconically seen as the symbolic and effectual leader, the bully pulpit of the nation, especially in times of crisis or in times of great national concern. We've looked to the office of the presidency to address these major issues. And the book does a nice job talking about really at the Civil War, as the nation was being torn apart, we looked to the presidency in order to bridge that gulf and pull the country back into one nation. And then, of course, the really difficult 45 years of World War I, World War II, and the Great Depression all required a very, very powerful executive. And the courts, over time, have largely allowed for the expansion of presidential power, especially in times of crisis. That's a historical lesson. I don't know how critical it is for you guys as legal studies majors, but you should know in the constitutional construction. Some of you are taking the history of the Constitution, some of you are taking political science. We're certainly going to go over the Constitution in those classes significantly in this class too. But we went over Article 1, which is the last chapter. And Article 1 deals with, I just have to check this right here. Article 1 deals with the legislature, which creates law. That's what, if you just really want a shorthand version of the three first articles of the Constitution, Article 1 is the legislature, bicameral legislature, which will create law. Of course, there are checks on its ability to create law, and one of the checks is from Article 2, and that's the executive. Now, you should know in the executive, it creates the eligibility who can be president. It must be a natural-born citizen, which means you're born in the United States, or I believe there's some interpretation that if you're born from parents who are United States citizens while they're in foreign service or things like that, there's some exceptions to that general principle, but they're very narrow. So generally, you have to be a natural-born citizen. You have to be 35 years of age. Remember, when the Constitution was created, when you're 35 years old, you're considered to be, well on your way in terms of being a mature and established individual. And that's about it. Born a United States citizen, 35 years of age, you're eligible. Obviously, at one time, if you were a woman, you weren't. At one time, you were a Native American, you probably weren't. If you're an African American, you weren't even thought of as African American. At one time, you were slaves, you were property. So these things have all evolved over time. But as a baseline, you have to be a citizen of the United States, born in the United States, and be 35 years of age to be eligible to be president. We know the electoral process is based upon something called the Electoral College vote. Very complicated. I'm not going to spend much time on it because I don't know how relevant it is to an intro to law class. But basically, Electoral College numbers, you have to hit 270. Each state gets a number of Electoral College votes based upon how many members in the Congress, House of Representatives and Senate, will determine how many electoral college votes your state. So very significantly populated states get more electoral college votes than less. So it's it's not. It's almost like a mirror at a circus or at an amusement park where it's a disjointed reflection of the popular vote. It comes close, but obviously in recent history we've had some presidents win the electoral college vote and lose the popular vote. The first one that comes to my mind is George Bush versus Al Gore. Al Gore won the popular vote, but he lost the electoral college. The other one is Donald Trump versus Hillary Clinton. Hillary Clinton won the popular vote, but Donald Trump clearly won. Actually, in his argument, he would say he won everything, but he did definitely win in a very big number of the electoral college vote. There's no question about it. He won and beat Hillary Clinton in that method by which we select presidents. And there's been a push, and I don't know how far it's going to go, to change the electoral college vote and do away with it. We could take a constitutional amendment where it would be one person, one vote, and it would be based purely on popular vote. So why do we have the electoral college vote? It was seen as a way to buffer from pure popularity and mob rule. They wanted a buffer to true democracy, and they thought by doing it with this method, less populated states would have a little bit more say, and it would weaken the large metropolitan regions so they wouldn't be able to dominate presidential elections. I don't know how effective it is. I don't know how popular it is, but that's the method we have. The first thing that started off in our early nation's history under the Constitution, which was adopted in basically 1789, and then, or some may say 1791, because the Bill of Rights were finally passed, the first 10 in that era. But up until 1804, there was a recognition that we had to change it because there was a tie-in between Aaron Burr. The way they had the method is whoever came in first in the electoral college vote, as long as they hit a majority, they didn't hit a majority, went to the House of Representatives. Still does. But if you hit a majority, it was whoever came in first place in a majority, and it was understood that whoever came in second would be the vice president. Created a couple problems. Well, one, if there's a tie, the person that might have really been running for vice president might end up becoming president. And that's not necessarily the intent of what the nation wanted. But secondly, you'd also have, as a vice president, somebody might be completely from a different party and philosophical perspective, and they saw a flaw in that the vice president and president should be sort of on the same page and the same team. At least that's what a lot of people think. And so as a result of the tie between Thomas Jefferson and Aaron Burr going to the House of Representatives, taking several different votes, we finally came out with Thomas Jefferson, but we realized as a nation we had to fix this process. So now the electoral college vote is distinct for president and vice president, but it has to be from the same ticket. So the Democrat wins the presidency, the Democrat wins the vice presidency, and same with Republican. So what's the role of the president? Well, it's a bit, I don't want to say vague, but it's just a couple of sentences, or even one long sentence describes the power of the presidency. And it's things like being the commander-in-chief of the armed forces, being the chief executive of the country, which largely has been interpreted, which is the most important thing for this chapter, has interpreted to be basically the branch that enforces the law. We have laws, they need to be implemented, it's going to go through the executive. There's many very important roles that the president plays, but I'm just trying to hit the high points. They appoint ambassadors to foreign nations with the consent of the Senate, so some of those roles are very, very critical, especially if you have sensitive negotiations that need to go on between the United States and some foreign nation. The president gets to name that ambassador with the consent of the Senate. The other is the president really is the sole conduit through which we negotiate with foreign countries with treaties. Now, that doesn't mean the president go out and create some nutty treaty and now we have to live by it. They can try to do that, but Senates need a 2/3 approval of the United States Senate in order for a treaty to become law. But in order to go out and actually negotiate these things, it goes through the presidency. So that's a very, very powerful tool. Now, I'm just going to go look at some of the specific ones because I'm going to figure out. Oh, and naming, obviously, judges. Federal judges are appointed by the president. Again, now this is just a majority vote, though, and that's the consent of the U.S. Senate. So sometimes the president might pick someone that has a very strong ideological view. The Senate might be too happy, and they'll shoot down that candidate. So the president often the Senate always does whatever the president wants. Well, that's not true. The president will consider thinking about these 10 people to name to certain roles in the federal judiciary. And they'll know ahead of time that, if I name this person, it's going to be a problem. They might not pass. So they want to save political favor and strength. They often name people that they think will likely pass. the Senate, they go out and do straw polling ahead of time. So there's a lot of politics behind the scenes. Um, I'm just looking for this specific ones here. Of course, I should have had it just outlined specifically. So I'll take care the laws are fully executed. That's the most important rule. Again, naming a diplomatic authority in terms of other parties and treaties. Um, Commander-in-Chief, I name that Navy and all the military, obviously. Make treaties, 2/3 votes of the Senate, already said that. Ambassadors, ministers, consuls. And here's the big one, the one we care about in this chapter. And that's why I wish the chapter was more about administrative law than executive, because administrative agencies really make up the biggest body of law. There's no question about it. The legislature creates basic goals with legislation, but the complexity of business, of life, of whatever it is, medicine, air travel, safety on the roadways, all of those things need to be dealt with laws, statutes. But the nitty-gritty of all the minutia that actually has to be considered, all the regulation that has to be done, Congress has to recognize the creation through an it's called enabling laws. And through an enabling act, they'll create an administrative agency like the FAA, dealing with how planes are going to navigate the airways, what's a safe plane, who can fly a plane for commercial pay, who can fly a plane just for recreation. All of those things go through the FAA. Now, the statute is broad enough to give us guidance that there needs to be safety in the way in which planes are flown and travel and all of those things. But the nitty-gritty in terms of all the minutia that has to be considered should be given to experts. So the Congress creates the Federal Aviation Administration, but here's where the power of the president comes in. The president gets to pick who heads those agencies, and that can be very influential, because if go for the EPA, for example, give me an example that's a little bit more political, the Environmental Protection Agency. Some people think that the Environmental Protection Agency needs to be very aggressive because of global warming and pollution and all these other things. Other people saying, this EPA stuff is just going too far and it's squelching business and putting a chilling effect on the economy for sort of radical science in their view. And so let's face it, if you are from one party and you become the president and you appoint the head of the EPA, they might have a very different viewpoint than if you're from the other party and you put in someone from the EPA. They might have a much more aggressive stance and take aggressive action. So it becomes important when you vote for them. That's one of the considerations when I vote for somebody for president. I think, who are they going to appoint to these different administrative agencies? On the state level, for example, I'm sure a few of you are in family law. Some of you actually want to practice in family law in some way. In family law, you might have to work with something called DCF or DOR. DCF is Department of Children and Family. It used to be called DSS. They have a statute that determines what their role is, and that's protecting the care and treatment of minor children who are either allegedly being abused or neglected. And they have to come up with a whole criteria in state law, foster parent care, when a biological parent might lose custody either temporarily or permanently. They create statutes that deal with that general theme of those things, but the actual implementation of all the minutia has to be done through an administrative body like DCF. And they create specific rules and regulations that are implemented through the head of those agencies, and on the state level, it's appointed by the governor of Massachusetts. And these laws impact you more than any others. If you're going to be in business, and staying with family law for a second, I mentioned DOR, the Department of Revenue, because there's all kinds of issues with child support and how that'll be implemented, and whether your wages can be garnished, and how much of your wages percent. Well, that's not necessarily in the statute. That's probably more likely to found to be, because it's in the nitty-gritty of the fine details, probably going to be found in different regulations. On the federal level, the regulations are called CFRs, the Code of Federal Regulation. And on the state level, we call them CMRs, Code of Massachusetts Regulations. And it takes time to know the acronyms. I don't like to speak in acronyms. I don't like to be spoken to in acronyms. I often get confused when people are using a bunch of letters and I don't know what they're talking about. I'm not afraid, though, now that I'm getting old, to say, what the hell does that 3-letter word mean? I don't even know what you're talking about. And when they say it, sometimes they don't even know what it means either, which I'm not trying to embarrass people, but acronyms can really throw you off. But over time, you're going to get the sense that, boy, regulations can play a very serious role. If you're into cars and autos and things like that, my father, I remember, built a homemade trailer, to carry brush. I don't know what to carry, the lumber, all kinds of things. I don't know how he made it, but he knows people. He used to be a plumber, so he knew welders, he knew carpenters and stuff, and he made this really ridiculous, unsafe, objectively unsafe trailer for a car and truck that we had as a kid growing up. And I can remember him getting pulled over one time, and of course, my father, being who he was, decided not to register it or have it insured. There was no license plate on this, so I got pulled over. And I remember the cop talking to my dad, and he goes, "Well, is this registered? Is this homemade?" And I remember the cop saying, "Well, this is supposed to have like mud flaps on it. It's supposed to have tires of a certain." I had these huge military tires. I don't know where my father got them from. But they were like bigger than the trailer itself, and there's no mud flaps to, I guess, protect people because it kicks up dirt and stuff off the road. And it was too wide. It was wider than traditional cars, and you would need a wide load permit, I guess. So there's all kinds of rules, and the rules aren't statutes. They are probably regulations and executed by administrative bodies. So the thing you want to know, there's some language, and I might as well go to the end of the chapter. I look at some of the. So the role of the president has expanded over time. It's not absolute. So sometimes the president, they think they're doing the right thing. And those of you that are into politics might hate certain presidents and love others. So, you think Lincoln did everything right. Did Lincoln sometimes go beyond the scope of the powers that were granted to him in the Constitution? Yes. And he got shot down by the Supreme Court after his death, of course. But nonetheless, in their own lifetimes, people like Obama and Trump both tried to do things through executive power, and it gets challenged through the courts, and the courts have nullified both of those presidencies' actions, even though probably both presidents think they're doing what's best for the country. That's not the standard. The standard is, do they have the power to exercise through executive orders certain kinds of behaviors or through their agencies? It's an important check on presidential power. Harry Truman is a perfect example. I might actually put a film up in this class. This is probably more likely if you're in the history of the Constitution. Harry Truman tried to take over the steel industry during the Korean War because there was a strike and there was steel production that was really slowing down. And he argued he needed the steel in order to fight in the Korean conflict. And one of the heads of the steel industry challenged him, also a Harvard Law School graduate, but he challenged him in the Supreme Court. And the Supreme Court says, President Truman, we know what you're doing is probably trying to do what's best for the country, but that's not the standard. The standard is, do you have the power under the Constitution to do that? And they struck down his executive order of taking over the steel industry and had to turn it back over. But like most things in politics, the steel industry kind of got the pressure, and the strike was ultimately resolved, and the country was back producing steel at the rate that was sort of acceptable to Harry Truman. But I'm way off track on that. So the recognition we create, now we don't, the legislature creates an administrative body. That administrative body is going to get into the nitty gritty. And what is it supposed to do? Not create law that's sort of unique or in its realm of expertise, but it has to be to clarify and implement the law that was passed by the legislature. Otherwise, it violates what? This is the test fodder question, if you will. It violates something called the delegation doctrine. A case just came down over the past few months here in the United States where the EPA was creating all kinds of new rules about emissions for greenhouse emissions to help curb the global warming problems. And some people challenge it, saying, hey, the EPA doesn't have that power. It goes beyond the scope of the enabling legislation. They're basically becoming a legislature of their own. And the Supreme Court shot it down, saying the nature of the rules that they were making went well beyond implementing the Clean Air and the Clean Water Act. And if they want to do it, the legislature can do it, but the administrative body can't. You can't delegate power like that and say, the legislature has a certain job, but we're going to delegate it to this administrative agency. Now, the legislature creates the framework and the skeleton of the standard, and the skeleton has to be clear and articulate, and everyone needs to know what his goals are. And the administrative agency is basically putting meat and sinew and muscle skeletal, binding into that enabling legislation. If the administrative body goes off on a tangent outside that skeletal framework, that's called a violation of the non-delegation doctrine. Even if Congress likes it, if Congress really likes it, they need to clarify the enabling legislation to give that administrative body that specific grant of authority to do so with the president's consent, because we know any legislation that comes out of the Congress needs congressional consent. So I'm just going to go through some of the key phrases at the end. So agency officers, here this goes to the delegation or non-delegation doctrine, how it's talked about here. It says, if it appears from the language of the Enabling Act that Congress did not clearly state as its purpose an intelligible principle to which an agency must perform, the Enabling Act will be struck down as void for vagueness. But then secondly, the second major aspect of challenging an administrative ruling or regulation is that the criterion of the delegation doctrine is that the agency's enforcement of law must be accomplished fairly and openly, and it must be consistent with that enabling legislation. In most things, you give somebody power, an agency power, they're probably going to go beyond the scope of that power, and they're going to do things that should have only been done by Congress, and that's the delegation doctrine. It's obviously very debatable. Otherwise, it wouldn't be going to the Supreme Court fairly regularly about whether or not an administrative agency went too far. So the administrative agencies, they're given this grant of authority. Think of the Food and Drug Administration. Whether I don't have any drugs on like a chapstick, that's probably the closest thing I have to drug on my table here, but is a drug safe? Is it appropriate? So we create legislation on that says, any drug that's sold over the counter must be, meet certain safety protocols. Well, it'd be the Food and Drug Administration that would be given the power to ultimately write the nitty-gritty regulations that deal with that. But if they go off the deep end, they're going to be pulled back either because the enabling legislation was too vague, or more importantly, that it violated the delegation doctrine. But when any agency wants to make a rule or regulation, think of the Fishing Administration, they want to make a rule or regulation how much cod you can catch, or what kind of equipment you can use to catch those fish. There's a controversy right, I think in Maine, but maybe in Massachusetts too, about lobster traps and about whether or not you have to use a different kind of lobster trap to avoid getting entangled with an endangered species called the right whale. That's not going to be done by a legislative act. It's going to be done by the FOA. It stands for Fish and I forgot what the acronym. There's my acronym problem again. It deals with the fisheries, and the question is there's a lot of controversy about it. So if I'm a lobster fisherman and they come up with a new regulation that I think really hurts me, I can't complain about it because I don't like it. I have to complain about it because it either goes beyond or the enabling legislation that gave the fishing agency that power, the ocean regulatory body, that power was void for vagueness. But more likely, I'll challenge it because it violates the delegation doctrine. It should have been an act passed by the legislature. And why? Because the legislature is responsible to the people with elections. Administrative agencies don't have that kind of responsiveness in our political process, and we want laws to be passed by our representatives, not our representatives, if you will. And that's almost what agencies are. The other main thing is when an agency wants to create a rule, they just don't do it. So you create an administration agency, Food and Drug Administration. I am producing a drug for arthritis. I can't just go and produce it. They're going to create rules for how drugs need to be manufactured, tested, scrutinized, all of those things. Well, when they create those rules, they can't just do it. They have to have something called a notice and comment period. This all comes under the Administrative Act. There's a special federal administrative act that determines how rules need to be promulgated. So they'll come up with a proposal. They'll advertise the proposal. They'll purposely try to publish it to give public notice to those who have a high stake in it. So if I'm a drug manufacturer, they'll really want notice and comment from me as a drug manufacturer, but they'll give it to the whole public. They'll put it out in the public notice records, and everyone will know that there's a proposed discussion about some new rule or regulation about drugs, about fishing, about airlines, whatever it is. And the public will have a right to give written testimony, to give oral testimony and show up at public hearings, to object, to approve, to lobby, because we want transparency in how these laws are created. Because think about it, if the agency is about to create a very unpopular law, what can we do? We can petition our legislature to reel in that administrative body, because the legislature is more powerful than the administrative agency, and they can curtail their power. There's no question about it. And political pressure sometimes does shape how an administrative rule or regulation will ultimately adopt it. So going through some of the things the administrative agency must do: one, it must be granted the power through enabling legislation. Two, the power must be so circumspect as only to implement the clear vision and protocols of that legislation. Otherwise, it violates the delegation doctrine. But the third thing that it must mean is public, open processes for adopting rules and regulations so the public can participate and voice their concerns and object and raise political hell. Now, let's assume some of the agency policy is coming out. They do all this notice and comment period. Everyone's against it. Can the agency still do it? Yes, provided it's not a violation of a statute or violation of a constitution. The agency has the power to do it, even if it's very unpopular. But obviously, if it's significantly unpopular, the legislature might reel in that administrative body and saying we're going to nullify that rule because it's just so downright unpopular. But man, agencies are everywhere. They're the biggest body of law. I call it the Rodney Dangerfield of law. Most of you know who Rodney Dangerfield is or was. He was a comedian, but his catchphrase was, "I get no respect, I get no respect." And he would segue into a joke about how he wasn't respected. The reason why I think administrative agencies don't get a lot of respect is when we think about law, most of us think about the Constitution, most of us think about statutes, and then a lot of us think about case law that has interpreted statutes and legal principles to give it binding authority from an appeals court called stare decisis and precedent. We think of that as law. Most of us don't walk around thinking about administrative rules and regulations, but when you really think about it, it's the thing that really, I think, regulates society. Think about the roadways, all the motor vehicle rules, the registry of motor vehicles. That's an agency. Financial aid, FAFSA, that's a federal administrative agency who's eligible for financial aid. When do you have to pay it back or you don't have to pay it back? All of those things are under agency rules. You want to open up a bar or restaurant, all those things about safe serve, I don't even know those rules. I know a little bit. My sister's doing a bar, but where you buy your alcohol from, how you keep track, how late you can be open as a victualler of all liquors. You're selling liquors, you can't be open all the time. You can't sell it necessarily retail. It has to be served and drank at the established. How many drinks you can serve an individual at any one given time. All those kinds of rules are not probably found in statutes. They're found in administrative rules and regulations. Biggest body of law. Oh, again, in the CFR, the Code of Federal Regulations are those administrative rules and regulations. That's where you'd find them. You can Google them and you find them. Now that we have all this wonderful data right on the internet, it's great. And the same is true of the state ones, which are called CMRs. Well, it's very important. I mean, it's not, who cares what the thing is here. Oh, and one of the things, if you don't like what an administrative agency's rule is, it gets adopted, you challenge it. You still have to go through the administrative process first. So you have the hearings at the FAA or the Registry of Motor Vehicles. And then and only then can you appeal to the courts to challenge the legitimacy of that administrative agency. That's called exhausting your administrative regulations and administrative remedies. And I've had that happen before. I used to do a lot of workers' comp cases, and you want to go to Superior Court with the case. And sometimes the defense attorney will challenge you, saying you don't have a right to be in Superior Court because you failed to exhaust your administrative remedies first, because they think that through the administration process, most problems and conflicts can probably be resolved. In that way, in order to go through the hierarchy of legal remedies and redress, you don't start off at the top. You start through the process. Just like a union contract, for example. I sometimes help the union at the college with controversy. You just don't take a controversy to court. You go through informal mediation, then you go through formal, then you go through arbitration. And once you exhaust all those tools, then you might be able to sue in a court of law. And so it's important to exhaust your administrative rate. If you ever hear that term, that's what it means. Just going, you have to go through the administration. Even if you think the administrative body is a violation of the Constitution in its existence, or it violated its rulemaking power, or it violated the delegation doctrine, you first go through all of their channels to see if you can win there before you actually go into court. That's all that really means. And now I'm looking at the chapter summary. Yeah, basically administrative agencies are through the president or the government, because they get to pick governor, or because they get to pick the heads of them with the consent of the legislature, the Senate. They in Massachusetts is the whole legislature. They help the president implement laws, usually with their philosophical outlook, right? And that's one of I think the most important roles of the president, besides foreign treaties, is in appointing judges, is the implementation of law. So if you're caught on the street, you're going to name what does the legislature do, what the president does, and what the courts do. The legislature creates law, the president implements law, and the courts interpret law. Very short. I mean, at least you got something to say, right? Again, agency authority is what? Limited to clarification and enforcement of the statute. It's not to create new statutory authority. It's to implement and clarify. Otherwise, it's what? Violation of the delegation. Now I go over these keywords, administrative agencies. What are those? Again, it's the legislature's, I'm almost going to say delegation, but that's not what it is. That's why it gets confusing. It's basically recognizing that the nitty-gritty minutia, the details of implementing the law, must be given to a specialized agency. And the agency is hopefully made up of what? Think of it. If I ever became a senator, which was always a dream of mine, become a senator from Massachusetts, a U.S. senator on the federal level, but coming from the state of Massachusetts, if I was in there and all of a sudden there's new dealings that we need to deal with aviation, because there's new types of planes or things of that nature, new technology. I don't really think about planes. I don't even like to go on planes, but I know there's a need to make sure we have safety in the airways. The FAA would be given that authority to implement the laws, the general theme of the law, which is safe aviation travel for both people in the air and on the ground, because things fall from the sky. Administrative Procedures Act, that's the method by which an agency will potentially create a new regulation. They have to give fair notice. There has to be public comment allowed and debate before they implement the rules. And if they don't, the act or the regulation is probably null and void as a violation of the APA, the Administrative Procedures Act. And I find it personally a very boring area of law. I thought I was going to be an environmental attorney at one time, and environmental law is very significantly based upon regulations, and the Administrative Procedures Act is the thing that's often bantered about as whether it's been complied with or violated. What is an enabling act? You should know that. Enabling act is the legislature's creation of an agency. Who appoints top federal agencies? The President of the United States does. Very important. When I vote for the President, everyone says, well, I'm voting because of this issue or that issue. I've got like a litany of 100 different things I consider when I vote for the President. One of them is, what kind of people is he or she likely to appoint to the heads of these different agencies, and what's the philosophy that they would probably put into place? It's an important consideration. This is where their power really comes from. The enforcement of law is critical. What is meant by exhaustion of administrative remedies? Already talked about that. You've got a beef about how an administrative rule or regulation has been applied to you or your company or your interest. You challenge it, but you challenge it through the steps that they have built into the Administrative Act, which we call regulation. What are the basic responsibilities of the President as outlined by the Constitution? We know that already the Commander-in-Chief of the military. The one thing that's not articulated there, they are really the symbolic leader of the country, especially in times of crisis. There's no question about it. But they are the leader of foreign affairs because they are the sole negotiator of treaties with foreign nations, but they have a check on them. They have to get consent of the Senate if a treaty is actually entered into. But they are also the chief law enforcement officer. And when I think about law enforcement, I'm thinking about criminal here. I'm talking about law enforcement officer in terms of implementing the law as it is, both civilly and criminally. And so therefore they have a lot to say. On the federal level, they also pick the Attorney General, which is the chief law enforcement officer of criminal law, but it still has to meet Senate approval. On the state level, it's a little different. At the state level, we actually elect our Attorney General, which has the charge of implementing state criminal law. And I'm going kind of fast. So just review the chapter. Purpose of administrative agency, just that recognition that the legislature can't deal with all the nitty-gritty of things that need to be structured. And so, they're going to create the skeleton, but the meat and the sinew and the tenets and ligaments, they all have to be put together by an administrative body. It's just a recognition that they can't get into all the nitty-gritties. We don't expect our Senator Elizabeth Warren and Ed Markey to really know about the details of the safety of food packaging, for example, or medicines, or even necessarily the eligibility for financial aid or things like that. Let's put people, and hopefully, to have expertise in that. The Board of Higher Education, for example, who do we expect to run that? Well, it's probably a politician who runs it, but in terms of all the people within the administrative, let's hope they have background in education and pedagogy or something like that. We hope. Sometimes people get appointed to agencies just simply because they're politically connected and have absolutely no skill or ability in that area. That's the darker side of politics, I guess. In what areas of law are administrative agencies appropriate? That's a bit of a trick question. I would argue almost in any, but it's those that have specialized knowledge and complexity. That would be my answer. What is the delegation doctrine? It's very, very hard to describe. Again, one last time. But certain things should be left to the legislature to determine because the people have voted for them and they're responsible for the people. They can't say, well, now we've got this other area that needs to be regulated and rules and laws need to be made. We'll give it to this agency. That goes too far. You have to give the agency the basic outline of the intent and purpose of the law, and basically they're going to fill in the narrow, nitty-gritty processes and standards by which it will be applicable. If it goes too far, it violates the delegation doctrine. In very recent history, very recent, it's 2022, if I have this video next year, I apologize, in 2023. But it's really in the news right now how administrative agencies in the legislature have been shot down because the legislature gave too much power to a regulatory agency that went beyond the scope of basically creating rules and regulations that implemented a clear intent of the legislature. The legislature punted and gave it to the agency too much, violates the delegation doctrine. And again, describe the minimum criteria for the creation of an administrative agency. It has to go through the Congress. The president has to approve, and there has to be a need for it. I mean, it's pretty straightforward. Kind of a dry chapter. I think the next chapter becomes much more, I think, fun if you're really into law, and that's substantive and procedural law, which is where I kind of make my money, and you will too. I think in the big picture. Otherwise, be well. Don't ever be afraid to say, I was going through a video. You didn't even touch this thing. I'm kind of curious about it. I don't get it. Don't ever be afraid to reach out. Shoot me an email. And if you really want to talk about it, because sometimes emails can be, we'll set up a time where we can always have a conversation because that can really clarify things too. Otherwise, be well.